All right, good evening, folks. Welcome to Monday Night Law here, November 13th, 2023. Okay, tonight I'm going to be talking about my trial by jury and then going into a little history of the law and some interesting things I found reading Blackstone's Commentaries on the Law of England. I'm going to mute my phone. We don't get any interruptions from there. All right. So, for those of you on Telegram and that tuned in a little bit earlier today, you got a little precursor, but and some other information that a lot of people were asking questions about on Telegram over the last 24 or even maybe even 48 hours. So I thought I'd just kind of get some of that out of the way on that stuff that was going on there. So you're welcome for that tidbit there. There's a lot of information to share, all the time. So kind of hard to keep up, but it is what it is. Hi CC from Alaska. What's the temp over in Alaska? What's the room temperature? We got an IQ higher than room temperature here tonight. Brother Thomas Klein, good to see you over there on YouTube. Karen, good to see you on YouTube. Brother Rob, over on Facebook. Rob was at the jury trial. It wasn't a trial by jury. So he got to witness everything that happened there. And I don't know if you're interested, Rob, even coming on, joining my Zoom meeting and coming on and talking a little bit, see what, a different point of view, right? And the Zoom number because you're in the Wednesday night workshop. So that's up to you, Brother Rob. If you want to join the Zoom, I'll let you in the Zoom here and you can, okay. You don't have to show your face. I hear you, though. Have to get you over that shyness. That's where I was at when I was doing blog talk radio. Didn't want to show my face. I was a little too shy. But after a year and a half of doing blog talk radio, kind of come out of my shell a little bit. So, yeah. I made my objections, and this is what I need people to understand here. Is that we have to create our record. And every time we make an objection, that is an appealable issue. And if it's based on a right, it becomes a constitutionality challenge. Okay, and that's taken up in federal court as a federal question. Now, this is even right out of Mason's Manual of Legislative Procedure that the courts provide oversight of what the legislature makes. So that's part of the next step of due process of law. See, the long game, right? We have to learn all of the steps of due process of law. And we have to know which branch of government has what powers, jurisdiction. And you have to have standing for a cause of action. You have to be literally subjected to whatever it is that's unlawful. Okay? That's what gives you the standing for a cause of action. That's your reaction to the actions they took. And so like I was explaining earlier today, and for those that were not on Telegram, I'm going to reiterate this, is that we have to create the record. Because, say, for example, when I do my criminal complaint, okay, everything that I've created in the record, not only is it an appealable issue when the judge denied my motion to dismiss. That is an appealable issue. Okay, this is all done in the trial court. And every document that I made, everything that I've done becomes the evidence. I've given them notice and afforded them the opportunity to do the right thing. Just document everything, right? The 4 W's: who did what, where, and when, comes from the paperwork. I have all of their names on the paperwork that they responded. Who the prosecutor was, deputy prosecuting attorney. Okay. I have the list of all the judge changes, every judge that took action, that conspired, that failed to ensure justice, who is in breach of their oath. Okay? So, all these things are done on purpose to create the record. And then when you go to file, wherever you go to file, you pull this up as that's your evidence. And you've got the who, did, what, where, and when. And you can cite your documents. And your documents become part of the evidence. Okay? So, I cannot stress this enough. Even when Chris and I were together, we could not stress this enough. You have to create your record. Okay? There is, again, no other way around this. No ifs, ands, or buts. Sui juris, of lawful age, of sound mind, and perfectly capable of handling your administrative duties, which means doing your paperwork, pleadings, and practice. The rules of the common law. All right? So, I made my objections to the, 6 men, and that the jury's not able to judge the law and the facts. Okay? And now, first question over here, Diesel D's, Brother Diesel, good to see you. What did the judge mean when he said my motion wasn't timely? Okay, at the pretrial conference, I made a motion in limine to limit that officer, his one witness, from testifying about anything about to do with the expired registration and the pullover and all that stuff, because none of those charges were filed by the prosecutor. So they're not adjudicated facts. So if they're not adjudicated, at this particular point it's been past a year, which is what I put in my motion in limine, to limit the witness from speaking. Now, on the timeliness of that, timely speaking, according to his jury instructions, it's within 5 days prior to the pretrial conference. It was filed 5 days prior. So he was stretching it, right? But what did he do? He went ahead and heard the motion in limine anyways, because he knew better. Even though he could say that isn't necessarily, it still denies my right to make the motion. And then the other thing is where's the objection from the plaintiff, or in this case the prosecutor? There was none. And he kept practicing law from the bench. Okay? The record's created. It's audio recorded. Okay? And audio video recorded, because I recorded it. According to his own preliminary statement there in Zoom, that this was considered to be a public hearing and can be live streamed. So if it can be live streamed, it can be recorded. So that's what I did, saving that as evidence. And remember, I accused him of treason for denying the right to a trial by a jury. That is a fundamental right of justice. And justice is to be without sale, denial, or delay, which again goes clear back to the Magna Carta of to no man will we sell, to no man will we deny right or justice. Okay, so again, you have to know the law. You have to be able to speak it. Our tongues are sharper than a double-edged sword. So, my people shall be destroyed for lack of knowledge. If you don't have this knowledge, how are you going to speak it? You just can't. If you don't have this knowledge, how are you going to put it down on paperwork and give them notice? Because, again, that is the first fundamental principle of due process of law. Notice and then opportunity to respond. So I've given them notice. Notice of motion. Here's the motion. Here's my arguments. Here's my affirmative defenses. Here's my claims. Okay? And all of my paperwork is verified under oath. Okay, under jurat, under oath. Now, to step into that real quick, here we go. So many people misinterpret this particular part of the Bible. This is James 5:12. Okay, people say, "Oh, we're not supposed to be swearing to God." We're not swearing to God. Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God, because thou shalt not bear false witness. And again, the maxim of law from God's law is there's no firmer bond among men than an oath. Okay, but here's James 5:12. But above all, my brethren, do not swear, either by heaven or by earth or with any other oath. But your yes is to be yes, and your no, no, so that you may not fall under judgment. There's the key. So that you may not fall under judgment. But we require an oath so you can be judged. Thou shalt not bear false witness. This is why our founders put it in there in Article 6, Clause 3, that it's required to have an oath as a member of the legislative, executive, judicial, both state and federal, shall be bound by oath or affirmation to support this Constitution. Fourth Amendment, no warrant shall issue but upon probable cause supported by oath or affirmation. Okay? So that you can be judged. Now, for those out there that are misinterpreting James 5:12, I just corrected your misinterpretation. Now go back and read James 5:12 with a better understanding of what it actually reads as it is written and what it means to be under oath. Okay? And I got a whole list of stuff here out of the Bible about the oaths and the founders. And of course, this is my founders Bible. So this is a really, really good Bible, and it's loaded with all sorts of goodies in between books and where our founders pulled from the Bible what certain things actually mean and why they did what they did. Okay? Right? That's the other thing is Rob's making the comment here that they included in the juror's oath verbiage that forces you to agree to only determine facts. And then they ask, is there anyone that didn't take the oath? Now, that was another thing that in the jury instructions, the right to trial by jury, which judicial notice, right out of Annals of America, Volume 2, the Virginia Declaration of Rights, June 12, 1776, the right to a trial by jury of 12 men of my vicinage, of my peers, without whose unanimous consent for finding of guilt, and that I have the right to demand the nature and the cause of action, and the right to confront my accuser and witnesses. So all of that was put on judicial notice. Now, whether the judge follows the law and ensures justice here or not is irrelevant. It's documented. I put him on notice of the law. Ignorance of the law. And like I told him, two maxims of law. Ignorance of the law is no excuse, and to know a thing and be bound to know it or regard in law is equivalent. Now that was during the trial when they tried to make the objection about me asking questions of the law to the police officer. And that's where I ripped him to new and said, how is this man claimed to be a law enforcement officer out here on the streets and highways enforcing law if he doesn't know the law and he can't answer questions on the law? And I cited those two maxims of law. And then I cited Article 6, Clause 3. He's bound to know this. 4th, 5th, and 6th Amendment, folks. And I specifically asked him if he was taught that. Okay? But again, I set up the record. Okay? And all of this gets to be used against him. Against all of them. It's evidence of their crimes. So, now that it's all been, essentially, the record's been completed, right? They've committed all the crimes they're going to commit, right? I mean, of course, they're going to try to go through a trial by jury, or jury trial again, because he claims it was a hung jury. It wasn't a hung jury. There's no such thing as hung jury. No double jeopardy. No man can be twice put in jeopardy for the same thing. For the same crime. Nope, nope, nope. You get one chance at this. And like I said, it's unanimous consent for finding of guilt. Not unanimous for finding this, because a man does not have to prove his innocence. He does not have to get consent from all 12, or in this case, like I said, in this case, 6, of his innocence. That's the beyond reasonable doubt standard, is the moving party has to get consent from all 12. If you do not, if there's just one that says, you know what, I don't give my consent, I'm not quite convinced, that is an acquittal. Now, I made 2 separate motions for acquittal. The first one was right after basically the trial was completed, that he failed to present an accuser. Again, right back to the judicial notice. So every time I do this, it is an appealable issue. Now, this is where I've gone back to, hey, Trump keeps telling people, somebody ought to sue these people. What do you think he's referring to? Doing the constitutionality challenges to all the corruption. Okay? Now, before we get into Blackstones and get down this rabbit hole, I want to stop right there because there was a woman on Telegram who shared this video with me. This just came out from the DOJ just, 3 or 4 days ago now. She shared it with me. Now, I've checked, did a little research, and like I showed earlier, the bill, which is on my computer up there, I forgot to share a link to it, so that I don't want to waste the time sitting here trying to find it again. But there's a bill that went through by Jim Jordan, and this committee is doing investigation, and it has to be done by January of 2025. But in the interim, they can be submitting stuff about corruption within basically the judicial branch or executive branch. So this ties into that. I have the Founders Bible, to answer your question over there on Telegram, of what kind of Bible do I have. I have the Founders Bible. Okay, so really good stuff here, and I've been informed that they were the DOJ is essentially being forced to do this. So this is great, and again, in my mind, this is in part of the going in under the continuity of government. And this is being instructed by the military to actually, this weaponized, in this instance, it was a weaponized federal executive branch, essentially. But what do you think is going to happen here is it's talking about in there that they have to look into the executive agencies like DOJ, the FBI. What are you guys doing? How are you guys obtaining this information? And they have to submit the law that they're acting under. Why do you think that is? It's so that it can be abolished. Because Congress would have no authority to do that. Because if it comes in conflict with our rights, or what they call constitutional rights right now. Okay? Let's just go with that. But this is quite interesting here. So listen up and listen carefully.
My name is Kristen Clark, the Assistant Attorney General for the Civil Rights Division at the U.S. Department of Justice. I am joined by U.S. Attorney Todd Gee, who serves here in the Southern District of Mississippi. Today, the Justice Department is announcing the opening of a civil rights investigation into the city of Lexington, Mississippi, and the Lexington Police Department to determine whether they engage in a pattern or practice of conduct that violates the Constitution and federal law. Specifically, we will assess whether the police department uses excessive force.
So, what are they doing? They're looking to see if they violate federal law, Constitution, 4th, 5th, and 6th Amendment.
Violates people's civil and constitutional rights during stops, searches, and arrests, engages in discriminatory policing, or violates people's civil rights to engage in speech or conduct protected by the Constitution. Lexington is a small community with approximately 1,600 residents and a police department with fewer than 10 officers. And in this regard, it is not unique. According to the Bureau of Justice statistics, half of America's police departments have 10 officers or fewer. The Justice Department is committed to protecting the constitutional rights of all Americans, whether they live in small towns or big cities. Residents of rural and underserved communities have the same rights and deserve the same protection as people who live in downtown Baltimore or the suburbs of Louisville. Police misconduct in smaller communities may not always garner national attention, but rest assured the Justice Department is watching. No city, no town, no law enforcement agency is too big or too small to evade our enforcement of the constitutional rights every American enjoys.
Okay. Notice that some people were mentioned, she was referring to the black people. I didn't hear anything about black people right there. Okay? So pay attention to what's actually said there. Yes, I get that she does reference black people there in this video. But she didn't mention it right there. So it's basically all Americans and our constitutional rights. Okay? And again, my source is telling that they're being forced to do this. Gee, I wonder why. Because people are filing complaints.
Small and mid-sized police departments cannot and must not be allowed to violate people's civil rights with impunity. Just recently, in August, we obtained guilty pleas from 5 deputy sheriffs in nearby Rankin County and 1 police officer from Richland, Mississippi, for beating and torturing 2 black men. Accountability applies.
Okay, now, they pled guilty to beating 2 black men. Well, it doesn't change the facts. I mean, just because they were black men doesn't mean this is all about black people. But even if it was, it's still rights. And we all hold these rights equally. That doesn't matter what color your skin is. These are God-given natural rights to due process of law, the right to be secure in our persons, papers, houses, the right of the people to be secure. Right? From governmental infringement. That's what this is about, folks. And this is part of the change that is coming. I don't know what else to do to wake people up and about understanding these 2 federal directives and the continuity of government, and that Trump is the commander-in-chief, which I got a little video about that. Thank you, Tony Franquito, for sharing that one with me. He flat out said commander-in-chief, that he's the commander-in-chief. Okay, this is a military operation per the Law of Nations, Law of War Manual. Like Derek Johnson's law and order. Laws and orders. Yeah, let's talk about some real law and not the United States Code. Let's go to the Law of Nations under war and peace. What the duty of the military is, which is outside of the Constitution. But in our Constitution, it's there. It's Article 4, Section 4. I've covered this several times since 2017 when this Executive Order 13818 came out.
Everywhere. And we hope this investigation makes crystal clear our commitment to ensuring constitutional policing in every corner of our country. Based on an extensive review of information that is publicly available and that we received from stakeholders, we conclude there is significant justification to open this investigation now. For example, there are allegations that Lexington police officers have stopped, searched, and arrested people without justification, used force against people who did not pose a threat to officers, used illegal roadblocks targeted at black drivers, and retaliated against people exercising their right to question police action or record police activity. The police department also appears to have violated First Amendment rights by routinely arresting people merely for using profanity. Community members have offered troubling accounts of how these alleged practices have affected their lives, of injuries caused by gratuitous and excessive force, of alleged sexual assault, and of repression and reprisal. We know, too, that these allegations arise in a community that has already faced racial discrimination and economic disadvantage. About 86% of Lexington's population is black, and it has a poverty rate approaching 30%. But it also has a storied place in civil rights history. In the face of violent opposition, residents persisted in registering and exercising their right to vote, and in 1967 elected the first black representative to the Mississippi State Legislature in the 20th century, who later went on to become Speaker of the Mississippi House. Underserved communities in the Deep South will not be left behind as we carry out our work to ensure constitutional policing across America. To be clear, this is
I know
the
that people want
beginning of the
to
investigation,
try to construe
not
this
the
about
end.
race, and
We
it's
have
not.
drawn no conclusions. We are committed to conducting an independent, comprehensive, and fair investigation. We will review incident reports, body-worn camera footage, and other information regarding the interactions of Lexington police officers with the public. We'll also review the police department's policies and training materials and other internal documents to understand how the
See, again, they're going to review all of this stuff. What are they being taught? Jax, it's not divide and conquer. This is going to affect everybody. That's why I pointed that out in the very beginning. All Americans, not just black Americans. Okay? This is just where they're choosing to do the investigation because people filed complaints. Squeaky wheel gets the grease. Okay? And the thing is it's if the blacks have these rights, doesn't everybody else? But I get that she's intermingling. But it's, look at the totality of what is happening. The police are being investigated to see if they're in violation of the Constitution, period. Okay? Grasp that just the totality of that. It's triggering some people. So, but it's not. It's going to have a profound effect nationwide. I promise you.
department operates. We will meet with police officers and observe them during their shifts to learn about their practices. And we will meet with members of the community every step of the way to hear about their experiences with the department. As in every investigation, we will follow the facts and the law wherever they lead. If we find a reasonable cause to believe that there is a pattern or practice of constitutional or statutory violations, we will issue a public report setting forth our conclusions.
Okay, where did she mention any race there? None. What are they doing? They're looking for constitutional or statutory violations. Okay? Again, what are they doing? They're doing an investigation to see if they're in violation of the Constitution and our rights.
And if we don't find such violations, we'll announce that result. And as always, we will not tolerate retaliation against community residents who participate in our investigation. In the event we find violations, we will seek to work cooperatively with the City of Lexington and the Lexington Police Department to reach an agreement on remedies. If we can't reach such an agreement, then the Justice Department is authorized to bring a civil lawsuit seeking injunctive relief to address violations. We look forward to working with city officials and the police department. We also look forward to working with the community as we carry out our work. We want the community to know that we see you, we hear you, and we will stand up for you. We have just briefed Lexington officials about the investigation and are pleased that they have pledged their cooperation. Since January of 2021, our investigations have included larger police departments such as Phoenix, Baltimore, Minneapolis, Louisville, and Memphis. And we've looked at mid-sized departments such as in Worcester, Massachusetts, and Trenton, New Jersey. The Lexington Police Department is one of the smallest we have investigated and one that represents most law enforcement agencies in our country. As I close, I want to note that our pattern and practice investigations have fueled significant reforms by law enforcement agencies. In Seattle, for example, the police department has reduced the use of force by 60%. Officers now use force in less than 1/4% of all events to which they respond. In Baltimore, the Independent Monitor found that officers are using force less often, and when they do use force, it is more likely to be consistent with police department policy and the law. And under the consent decree in Albuquerque, New Mexico, use of force declined by 25%, and violations of the force policy fell by half. Misconduct by law enforcement, excessive force, discrimination, illegal stops and searches, violations of First Amendment rights. All of this abuses and undermines public trust and harms racial minorities and other vulnerable populations.
Now, I get that she threw that in there right there. Okay? So the thing is if these minorities and other races have these same rights, don't the rest of us have these same rights? Because that's what they're saying is essentially they're being picked on. And if it violates a black man's or a black woman's rights, doesn't it violate another man's right of a different skin color? Because we all have these rights in common, right?
This discredits law enforcement. These problems, though, can be fixed. It is possible to restore public trust, to build a working relationship with the community, and to instill in departments a culture of non-discrimination and...
No, Jax. I'm not siding with defending the police. They're under investigation for their conduct. Is it in violation of the Constitution, our rights? That's what they're being forced to do. See the bigger picture and plug it into the plan that's going on right now. Is to return us back to a government de jure republic where the Constitution is upheld. And again, I reiterate, the New York Rifle and Pistol Inc. versus Bruin, the Roe versus Wade, overturning the Roe versus Wade, the Rahimi case. Now we got that, and these are all Second Amendment cases here. The case out of California in the federal district court, not the appellate court, but the district court. Now, again, it's a toss-up between who's the most corrupt, California or New York, because, California is actually where the UN was created. But New York is the New York Rifle and Pistol Inc. versus Bruin that struck down any legislation that requires us to seek permission to carry, open carry, anything, to carry it all. Okay? The Rahimi case struck down the domestic violence protection order requiring people to turn in their arms to the local sheriff. That was declared. That was by Congress. So that was declared unlawful and unconstitutional of Congress to create that legislation. Because, again, the right to keep and bear arms goes all the way back to the laws of nature. And then the case out of California, which is just recently, was out of San Diego, federal district court, which declared unlawful and unconstitutional the banning of semi-automatic weapons and large capacity magazines. California. Okay, prima facie evidence, we're returning back to the fundamental principles of the Constitution and our rights. And this is what I need people to understand here. This right here that we're watching right now from the DOJ, they're being forced to do this because people filed complaints. Let me reiterate that again. They're being forced to do this because people filed complaints, criminal complaints. Okay.
Respect for constitutional rights. We are committed to working with officials in Lexington to achieve these goals. The Civil Rights Division of the Justice Department is pleased to conduct this investigation in partnership with the U.S. Attorney's Office. I'll now turn the floor over to my colleague.
In partnership with the U.S. Attorney Generals? I thought that was the DOJ. Now this is why I teach people to go to the federal district building and go to the deputy prosecuting attorney general, the deputy attorney general, the executive branch. Go directly there with an AO91. Okay? Now, I don't know if I really want to play much more of this because I hope we get the gist of what's going on here, folks. I get that some want to try to, and that she even may be trying to construe it as that. But listen to the totality of the words she said to see if they're in violation of the Constitution and our rights. To see if the police are acting unlawful. What is their curriculum? What are they being taught? What is this going to do? This is going to open up a serious frickin' can of worms. And I mean huge. Because it's getting into the curriculum of what they're actually taught, their policy. Try to find out why they think they can do what they do. That's the key to this. Finding the root of the cause. It's the maximum laws. The cause is the cause of the cause of the result. Okay, so that's what they're looking for. They're looking for the cause of the cause. And then what the end result is the cause that causes the effect. The effect is going to be to shut this corruption down. Those involved in serious human rights abuse and corruption. That's what this is really about. Okay? We're starting to get down into America stuff, right down to a city level. That's what this is about. Okay? so many people. Nitpicking on stupid little things is not going to change anything, guys. Stop. Look at the totality of what is going on. Okay? Now, let me see if I can get this pulled up now, if I can. All right, so we're talking about trial by jury, right? I believe it is in Article 3, Section 2. Yeah, right there. Clause 3. The trial of all crimes, except in cases of impeachment, shall be by jury. And such trial shall be held in the state where the said crime shall have been committed. But when not committed within any state, the trial shall be such place or places as the Congress may by law have directed. It's in Article 3, Section 2, Clause 3. So 323. Now, we also have that same right in the Bill of Rights. Now, let's just go to the Fourth Amendment real quick. The Fourth Amendment originally enforced the notion that each man's home is his castle, secure from unreasonable search and seizures of property by the government. It protects against arbitrary arrests. It protects against arbitrary arrests and is the basis of the law regarding search warrants, stop and frisk, safety inspections, wiretaps, and other forms of surveillance, which is part of that bill that Jim Jordan put in, as well as being central to many other criminal law topics and to privacy law. Okay, the right to be secure. The right of the people to be secure in their persons, house, papers, and effects against unreasonable searches and seizures shall not be violated. So this is what they're doing. They're doing an investigation to see how they're being violated. Where's the policy? What's telling these guys that they can do what they're doing that's in conflict with the Fourth Amendment? That they're making these unlawful arrests. Now, this is the thing I'm going to be doing. I'm going to be challenging this. I'm going to be doing the constitutionality challenge to the original arrest. Challenge to the entire Idaho Code, because the code is the Roman civil law. Again, many people are not aware of that. Squeaky wheel gets the grease, folks. Somebody ought to sue these people. That's what I'm going to do. And this is going to have a huge effect on everybody. This is the long game. Right? They denied my motion to dismiss, where I asserted all these grounds and it was an unlawful arrest and then lack of personal jurisdiction and all that good stuff. That's already documented. It doesn't matter. They continued on. They denied, like I try to teach people. The trial court you go into, the first one, the de facto kangaroo court. They're by evil design to deny. Because they want us to file an appeal and fight this up, and then, the judicial branch just says, no. We got this over here. This rule of procedure over here says, just like what this guy did, my magistrate. Okay? He didn't cite any law. He only cited some rule of procedure and some case law behind it. And I specifically asked him, where in the Constitution does it delegate the power to the judicial branch to make law or even to alter the law? He just couldn't answer that question. So, he failed to cite law to support his deprivation of the right. That is a constitutionality challenge. That is taken up in a different court. I've already made that challenge here in the trial court. These are what is known as errors in the trial court. Okay? So we have to understand how due process of law works. And all of the steps to go all the way through. Okay? Now the Fifth Amendment. This is a key one, because this is the one that requires a grand jury indictment. No person shall be held to answer for capital or otherwise infamous crime. There's your so-called felonies and misdemeanors. It's in my Criminal Practice Act of 1864 for felonies and misdemeanors, and all crimes are a misdemeanor, and it's all required to have a grand jury indictment. They didn't do that. That's in part what I made my objection, for the grounds for acquittal, the first one. No grand jury indictment. No accuser. So I've created my record. And when I go up to federal court, right? That's right. And do the constitutionality challenges, this is how we get the law back to being enforced. You're preaching to the choir about the bar, to me. Remember, I've been going after the bar. You might be new here, but I've been working on going after the bar with Chris Hallett, which my partner then, we went to Congress challenging the bar as a monopoly and you can't license the practice of law in 2017. Now, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. There's your territorial jurisdiction right there. So for those that try to argue territorial jurisdiction, there it is right there. There's your territorial jurisdiction in the Sixth Amendment. Okay? So, which district shall have been previously ascertained by law? Okay, I'm in the 4th Judicial District. It has been previously ascertained by law. Territorial jurisdiction. And to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him. Now, see how they left out accuser. So we have to go back in history a little bit. And to have compulsory process for obtaining witnesses in his favor and to have the assistance of counsel for his defense. Nowhere does it say a member of the bar to be represented by a member of the bar. It says assistance of counsel. Keep that in mind. So, now that we understand that we all have this right to trial by jury, this is the declaration of the cause and necessity of taking up arms. I'm going to go over here to the Declaration of Independence so that we can get an understanding of what some of the causes for the separation was. See, that's what this says here. A decent respect to the opinions of mankind requires that we should declare the causes which impel them to the separation. Okay. He has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance. Now this would be those policy, They pronounce it police, but it's policy officers, which it's even in Blackstone. You're gonna see it here in just a little bit. It's written as police, but it's policy, as well as in some of the original founding documents, Constitution 1776 era, says internal policy, police policy. He's kept among us in times of peace standing armies. Those are those armed bodies of men without the consent of our legislature. He's effected render the military independent and superior to the civil power. Now, here's where we're at. He is combined with others to subject us to a jurisdiction, a body of law, foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation. Okay. How about for depriving us in many cases of the benefits of trial by jury? What are some of the benefits of trial by jury? How about to judge the law? This is in one way, how we exercise political power, more specifically the right to alter, reform, or abolish anything that has been unlawfully created. This power has been stripped from the people. Our common law courts, where we would challenge that. And the jury would decide whether the legislature, see the judicial branch, this is part of the judicial branch, right? The trial by jury is part of the judicial branch. But it's not really, it's the common law. So, this is it. That's one of the benefits, and it's part of our political power. Number two, that unanimous consent part. The part about, an impartial jury. One that's supposed to be of our peers and all that good stuff. Without whose unanimous consent. They're depriving of us of the benefits of a trial by jury. You get one shot at this, dude. And that's it. If you don't get unanimous consent for finding a guilt, that is an acquittal. And I made the motion for acquittal, the second one, on those grounds because it polled the jury. And I want to thank juror number 7, which is the one that I actually wanted on the jury, was hoping that he didn't exclude him, because he's the one in the very, very beginning, before we got into the jury selection itself, he made the comment that he thought it was wrong that these police officers are out there jerking people out of the cars for traffic tickets. And he held out. He was the one man that held out. And let me tell you, they were kind of pissed at him for not finding me guilty. Everybody else wanted to find me guilty, even after everything that I laid out to him and got the officer to testify. No, there was no crimes. We went through the tickets. I put them in as Exhibit A, B, and C. A and B were the 4 charges of expired registration, revoked registration, no insurance, and driving without privileges. The prosecutor did not file any of those, because I have a previous case from 2013, actually, but it was done in 2014 where the prosecutor dismissed because I don't have to have a driver's license. None of this traffic code crap applies to me. That's why that case was dismissed, because that was in my right to travel brief, and we were getting ready to go to trial, and I didn't know enough about how to conduct a trial by myself back then. So I asked for the assistance of counsel to assist me with the trial. And when the public defender went through my paperwork and said, yeah, all of this stuff's going to be judicial notice, and the jury's going to be fully informed here. And the prosecutor did not want to go to trial against me. And it came right down to the question that my own public defender asked me. Do I think that I do not have to have a driver's license? And I said, well, yeah, I went through all that, and now I don't have to seek permission to exercise a right, because that's what a license is. And I shepherdized quite a few of those cases. So I have plenty of supporting evidence that the judicial branch has already ruled that we already have this right of personal liberty. They want to call it right to travel. But it's actually the right of personal liberty, the right to the power of locomotion, coupled with the right to acquire and possess property. Utilize our property as we see fit. Okay? So, now the next one I want to point out here is right here. For suspending our own legislatures and declaring themselves invested with the power to legislate for us in all cases whatsoever. Would that be them common law courts? Suits at common law, where they could be criminal in nature or civil in nature? Oh, right, yeah, that's right. Suits at common law can be criminal in nature or civil in nature. So when our republic comes back and we reassemble, our common law courts are going to come back, and we're going to be able to prosecute public servants, criminal in nature, in a common law court under the rules of the common law, because it can't be heard in any courts of the United States except for pursuant to the rules of the common law, and has to be heard by a common law jury. That's the law. And I'm saying law as in rights as the law. The rights dictate that. Don't need any statutes for that, because that's long before the common law is before the Constitution. Long antecedent to the formation of the state, to cite Hale versus Henkel. All right. So, we'll come back to this jackwagon here in just a minute. But take a good look here. Stephen, King of England. I want to point out, his time of reign was 1135 to 1154. Okay. Now this is Blackstone's Commentaries on the Law of England. And it gets into, we're going to find this stuff in here about the trial by jury, the root of the common law. I found it. Imagine that. So, this is actually Volume 4, Section 379. Upon these accounts, the trial by jury ever has been, and I trust ever will be, looked upon as the glory of the English law. And if it has so great an advantage over others in regulating civil property, how much must that advantage be heightened when it is applied to criminal cases? But this we must refer to the ensuing book of these commentaries, only observing for the present that is the most transcendent privilege which any subject can enjoy or wish for, that he cannot be affected either in his property, his liberty, or his person, but by the unanimous consent of 12 of his neighbors and equals. A constitution that I may venture to affirm has, under Providence, secured the just liberties of this nation for a long succession of ages. Which one would that be? Would that be that Magna Carta? The Great Charter of Liberty? And therefore a celebrated French writer who concludes that because Rome, Sparta, and Carthage have lost their liberties, therefore those of England in time must perish, should have recollected that Rome, Sparta, and Carthage at the time when their liberties were lost were strangers to the trial by jury. Now, the origin of trial by jury here, let me get into that, because this is a different book over here. This is my Bills, Quills, and Stills, an annotated, illustrated, and illuminated history of the Bill of Rights by Robert J. McWhirter. When I was out there in D.C. with John Gentry in 2018, went into the Supreme Court there and went to the gift shop, and I saw this book and I thought, I gotta have this book. This is the one that refers to right here about the right to trial by jury. Oh, I thought I had this open to that. Refers to this section 379 of Blackstone. But there's there's a lot to the jury. There used to be a trial by dueling, and those other kinds of ways, which is different forms of the code and law stuff. So we'll get into that in a minute. But I wanted to show the citation right here. Oh, this is 3 Blackstone Commentaries on the Law of England, 379. Okay, so I guess I must be in 3, not 4. Yes, I'm in Book 3, Volume 3, subsection 379. Okay, so that's how I got here from this book. So this is how we do research, right? You get a book and you look at their sources. What are they citing? Oh, well, this is 3 Blackstone Commentaries on the Law of England, 379. So I come here and this is what I find. Okay? So this is how you do research. This is how you go down the rabbit hole. Okay? So, back to the not be affected either in his property, his liberty, or his person, but by the unanimous consent of 12 of his neighbors. It doesn't say unanimous non-consent for innocence. It's unanimous consent of 12 of his neighbors and equals. And then, furthermore, the Aziz of Clarendon is actually 1166 and 1164, technically speaking, from reading, is actually where the trial by jury came from. But it used to be, in part, was the Parliament, which was sometimes 300 to 600 people. So if you can imagine that, gee, I don't know, petitions to the legislature, to Parliament. Yeah. Okay. So, Diesel D's. But how do we get there if there currently aren't any common law courts? Well, see, this is where they've legislated for us in all cases whatsoever here. Title 42, 1983, if you look at Title 42, 1983 United States Code, it says it's a common law jurisdiction. So it's there. They've just stolen it, the power, and they've taken it away from the people because they didn't want us doing constitutionality challenges in the trial court, in our common law courts, and abolishing their unlawful legislation. That's why they did that. They wanted their Roman civil law, which we're going to see here in just a minute. That's just down here at section 421. Okay. So, I mean, if it's here and one of the reasons why that I've come here and started really wanting to start studying Blackstones is because of this New York Rifle and Pistol Association versus Bruin case right here. What does he talk about here? Talking about quoting from 4th volume of Blackstone Commentaries at 148 to 149. That's one place that they cited. Okay? And I haven't found the other one that they cited in here. Was talking about going back to the law of nature. So I'm not going to waste time looking for that right this second. I want to get back to this. Because there's some really good stuff here. Okay? But in that case, it says that our right to keep and bear arms comes from the law of nature as the right of self-defense. Great is this eulogium, whatever it may seem, it is no more than its admirable constitution, when traced to its principles, will be found in sober reason, so in other words, of sound mind, to deserve this trial by jury. The impartial administration of justice, which secures both our persons and our properties, is the great end of civil society. That's so that no man is being deprived of his property, his rights, his liberty, or his persons, like business, right? Without the consent of a jury. And this is how the people pushed back against tyranny. That's why that power was put into the hands of the people. It was retained by the people. You know, the power's not delegated to or prohibited by, is reserved to the states respectively or to the people. That's a power that was retained by the people. So, when I go do my constitutionality challenge, I get to bring up this history of the law on the right to trial by a jury. And I get to declare all of this stuff unlawful and unconstitutional. And we get to bring back our true nature of our right to trial by jury. But this is the long game. And this does it for everybody. This is what I try to teach. And I made the post out there earlier that, I want to train warriors to win the war, not to win one little battle. So this is where I'm going to put the plug in there to join me over there on Patreon, where I'm teaching this stuff in great detail in the Wednesday night workshop. Go to my website, kirkslawcorner.com. You can click on the P up there or right there on the homepage there. You link to Patreon. And that's tier 3. If you want one-on-one time with me, that's tier 4. Otherwise, tier 1 and tier 2 are just to help support. Basically a monthly donation. And I greatly appreciate everybody that's on Patreon right now. Thank you for all being there and supporting. And of course, in tier 3, your willingness to be there to learn. Okay? So that's what that's all about. Do you want to learn? Like Chris used to say, do you want to fight or do you want to win? I want to teach people how to win. And win good in such a way that it takes it down for everybody else. Stop being selfish and wanting to win just your case, turn around and walk away. No, keep going. Okay. Let's see. Principles of administration of justice. But if that be entirely entrusted to the magistracy, a select body of men, and those generally selected by the prince, or such as enjoy the highest offices in the state, their decisions, in spite of their own natural integrity, will have frequently an involuntary bias towards those of their own rank and dignity. Would that be that protecting them from the murders they've committed by mock trials? That's in the Declaration of Independence. That's what he's referring to there. And this is before the Declaration of Independence, by the way. It's funny that Blackstone knew this then. Okay? It is not to be expected from human nature that the few should be always attentive to the interests and good of the many. On the other hand, if the power of judicature were placed at random in the hands of the multitude, their decisions would be wild and capricious, and a new rule of action would be every day established in our courts. It is wisely therefore ordered that the principles and axioms of law, or should be maxims of law, which are general propositions flowing from abstracted reason, and not accommodated to times or to men, should be deposited in the breasts of the judges. Oh, you mean we should follow principles or the rule of law, maxims of law? That's what the common law is, folks. We're going to get into that here. It's just right here, okay? That's what the common law is about. It is wisely therefore ordered that the principles and axioms of law, which are general propositions flowing from abstracted reason, logic and reason, and not accommodated to the times or to men, because these become principles. The plus sign, the minus sign, the multiplication sign, the division sign are principles or maxims of mathematics. They dictate the correct answer every time. And this is what we need to get back to, these maxims of law. Okay? To be occasionally applied to such facts as come properly ascertained before them. Now, you got to bring forth some facts, and then you use the maxims of law to determine the outcome. Because that's real law, common sense law. For here, partiality can have little scope. The law is well known, is it? Not today, it's not. And is the same for all ranks and degrees. Oh, are you saying the law is supposed to apply equally to all? Going back to the video by the DOJ being forced to do this, that's what's happening. The law is starting to be applied to all. Remember, we're talking about this double standard, especially by the DOJ. Trump talking about this, that they're so corrupt, that there's a double standard. That's why they're being forced to do this investigation. And I get, they're trying to make it about race and all that good stuff. That's because they're being forced to do it. So they're really trying to muck it up to get people to go, oh yeah, you're doing it just for the blacks. You got to look between, they're still corrupt, but they're being forced to do it and expose their corruption. They're going to expose their own corruption. Because again, ignorance of the law is no excuse. Everybody's supposed to know that. Even Blackstone says it right there. The law is well known. That's a maximum law. Ignorance of the law is no excuse. And then to know a thing and to be bound to know it are regarded in law as equivalent. Are you bound by the Constitution or not? Are you a member of the executive branch, Mr. Police Officer? Well, you're already deemed to know this. And guess what? The judge overruled that objection from the prosecutor because I made those arguments and applied maxims of law. I cited the law, Article 6, Clause 3, and then used maxims of law to force the judge to rule correctly in open court and on the record and in front of the jury. That's how you do that. All right. And everybody was confused. Even at first I was kind of confused myself. So I'm thinking, okay, basically he just ruled in my favor. So now what? And then the judge looked over to the police officer and said, you need to answer the question. And the cop was like, you were supposed to protect me, judge, prosecutor. I'm being thrown under the bus. That's because you're dealing with somebody who actually knows law and knows how to make these arguments. I'm not a member of the bar. I'm here to create my record. I'm not messing around here, guys. What I'm doing is going to benefit everybody in America. And this is what everybody needs to understand here. All these other guys out here think they know what they're... Oh, why'd you go into subrogation? because that's not law. It's shmew, shit made up by man, and not only that, subrogation is an alternative resolution process. It's not due process of law. That's why it's not law. Number two, you have to have consent of both parties. Oh, you guys didn't read up on subrogation? You don't understand how subrogation is actually supposed to work as per the code, the Roman civil law? But I can't find subrogation in the Constitution or any Bill of Rights. So therefore it's not lawful, full of law. That's why I'm not doing subrogation. And again, what I'm doing is much bigger than just myself to win my own case. This is to expose the corruption, do constitutionality challenges, and shut this down for everybody. It's time to end this corruption, to expose it and shut it down, following due process of law. And it is time. It is ripe for the picking. I mean, this was just a few days ago with the DOJ stuff. Okay? So, and then if you watch the video on Telegram that I shared out there, the pre-Monday Night Law video that I just did earlier today, that, I showed the bill in there, what they're doing in committee is doing an investigation of the executive branch and all these agencies and what they're doing that's unlawful and unconstitutional. It's ripe for the picking, folks. Trump keeps saying somebody ought to sue these people. Well, be a somebody. To quote Cara Miller, somebody ought to do something about this. Well, be a somebody. God rest his soul, Cara Miller. You inspired me to be sitting right here, right now, and doing what I'm doing by saying those words. Somebody ought to do something about it. Be a somebody. By golly, I'm doing it. So thank you, Cara Miller. Nature of you should always adjudicate place for random and hands of multiple principles of access law. Okay, now to accommodate the times of men should be deposited in the breast of the judge to be occasionally applied, so it's probably ascertained before them. For here partiality can have little scope. The law is well known and is the same for all ranks and degrees. Again, the law applies equally to all. Back to that double standard that Trump was talking about. We've talked about it. I always say, law for thee, not for me. Or like my uncle and I, when we talk about it, it's Judge Dredd. I am the law. No, you are not, and you're about to find out real quick. It follows a regular conclusion from the premise of fact pre-established. Fact pre-established. But in settling and adjusting a question of fact, these maxims of law help with that. These principles, right? The fact is we have two things plus two other things should equal four things. And the principles dictate that correct answer. The maxims of law, or the rule of law, the rule of mathematics. Okay, are we getting what a principle is here yet? What a maxim of law is. Okay, keep that in mind when we go and we discover here. I show you what I discovered in Blackstone's about the origin of the common, in italics, law. When illustrated to any single magistrate, partiality and injustice have an ample field to range in, either by bodily asserting that to be proved, which is not so, or by more artfully suppressing some circumstances, stretching and warping others, and distinguishing away the remainder. Here, therefore, a competent number of sensible and upright jurymen, chosen by lot from among those of the middle rank, will be found the best investigators. What? Wait. This is where it's going to get good about the trial by jury, folks. Of truth and the surest guardians of public justice. For the most powerful individual in the state will be cautious of committing any flagrant invasion of another's rights, because the jury's supposed to actually do the investigation. Uh-oh. That would be one of them benefits of a trial by jury. And what does it say here? Be the best investigators of the truth and the surest guardians of public justice. For the most powerful individual in the state will be cautious of committing any flagrant invasion of another's right when he knows that the fact of his oppression must be examined and decided by 12 indifferent men, not appointed till the hour of trial. And that when once the fact is ascertained, the law must, of course, redress it. Did you usurp your power and deprive me of a fundamental right? Well, sucks to be you, because this process been around for a long time. And notice that it's going after public servants. It's designed to go after public servants, not the people. The people's supposed to be the jury. That's a good question, Art Patterson. Good to see you on here, brother. I'm not sure when the last legitimate trial by jury in the United States was. My guess it's definitely before 1930. I'm not sure. I don't know. I don't know. They implemented the Roman civil law in Idaho in 1881, that Code of Civil Procedure Act of 1881 in the 11th session, before our Idaho Constitution. So, could have been around that time. Trial. And that when once the fact is ascertained, the law must of course redress it. This therefore preserves in the hands of the people that share which they ought to have in the administration of public justice, and prevents the encroachments of the more powerful and wealthy citizens. Time to bring back our trial by jury, isn't it? Our common law grand juries and petite. It's not petite, it's petite, as in small. You know, like a woman is petite. Go into the petite section. It's petite. Say it correctly, folks. Petite. Small. It's 12. Grand jury is 25. Okay. Every new tribunal erected for the decision of facts without the intervention of a jury, whether composed of justices of the peace, would that be that common law court with a justice of the peace? Commissioners of the revenue, judges of a court of conscience, or any other standing magistrate, is a step towards establishing aristocracy, the most oppressive of absolute governments. The feudal system, which, for the sake of military subordination, pursued an aristocratical plan in all its arguments of property, had been intolerable in times of peace had it not been wisely counterposed by that privilege, so universally diffused through every part of it, the trial by the feudal peers, and in every country on the continent, as the trial by the peers has been gradually disused, so the nobles have increased in power. So when they started taking away the trial by jury of peers, that's when the nobles increased in power. That checks and balance. Till the state has been torn into pieces by rival factions, and oligarchy in effect has been established under the shadow of regal government de facto, unless where the miserable commons have taken shelter under the absolute monarchy as the lighter evil of the two. Again, this is before our republic. And particularly, it is a circumstance well worthy an Englishman's observation that in Sweden the trial by jury, that bulwark of northern liberty, which continued in its full vigor so lately as the middle of the last century, is now fallen into disuse. Wonder why? We're going to find out here in just a little bit why that Roman civil law came back into use. And that there through the regal power is in no country so closely limited, yet the liberties of the commons are extinguished, and the government is degenerated into a mere aristocracy. It is therefore, upon the whole, a duty which every man owes to his country, his friends, his posterity, and himself, to maintain to the utmost of his power this valuable constitution in all its rights. But don't you think you have to know it first? But this even goes back to the law of nations. As a patriot, we're supposed to do this. And that's why I'm doing what I'm doing, because I have my love of country. And this isn't even just a love of my country, of my nation called America, but a love of mankind as a whole, worldwide. I'm going to blow this popsicle stand wide open. Or would that be the corn pop stand? Corn pop. All right. To restore it to its ancient dignity, if at all impaired by the different value of property or otherwise deviated from its first institution, to amend it wherever it is defective, and above all, to guard with the most jealous circumspection against the introduction of the new and arbitrary methods of trial, which, under a variety of plausible pretenses, may in time imperceptibly, that was impersonability, undermine this best preservative of English liberty. So, if it was a right so established and declared through the Magna Carta, this ancient constitution, it can't be subverted, changed, limited through succession of law. Only further expanded upon and grant more power to the people. And that's what our founders did. They fought for this. Yet after all, it must be owned that the best and most effectual method to preserve and extend the trial by jury in practice would be by endeavoring to remove all the defects, as well as to improve the advantages incident to this mode of inquiry. Oh. An inquiry? An inquest? An inquiry? Grand jury? Inquest? Huh. If justice is not done to the entire satisfaction of the people in this method of deciding facts, in spite of all economiums and, panegyrics on trials at the common law, they will resort in search of that justice to another tribunal, though more dilatory, though more expensive, though more arbitrary in its frame and constitution. If justice is not done to the crown by the verdict of a jury, the necessities of the public revenue will call for the erection of summary trials. Oh. It's like this. It's like telling history, but it's also telling the truth of what's happening again right now. So now let's get into these principal defects that Blackstone lays out here. So the principal defects seem to be 1, the want of a complete discovery by the oath of the parties. Okay, I already covered that. James 5:12, why it's required to be under oath, so they can be judged. This each of them is now entitled to have by going through the expense and circuity of a court of equity. And therefore it is sometimes had by consent even in the courts of law. Now, this is where the distinction between courts of law and courts of equity is. And the way our founders set this up was to retain this power at common law, suits at common law. Right? When we go into suits in equity, then that goes in under Article 3, Section 2. Then that gets into a court of the United States, takes that power away from the people. So we want to keep this power retained in the people's hands to decide the facts of whether or not that public servant usurped their powers and deprived me of a fundamental right. They're the ones that decide that. Not the judge. Not the DOJ. Okay? Not FBI, not your sheriff, not your police officer. That's the fox guard in the hen house. Why would they investigate themselves? Well, that's the mock trials, protecting them from the murders they've committed on the inhabitants by mock trials. That's what that's referring to. Well, we did our investigation and we found no fault of the police officer. How many times have we heard that over the last 50, 60 years, 70 years, 90 years? If you talk to my grandmother, who's 92 years old. By the way, I still talk with my grandma. She lives across the street now. And, we've had lengthy conversations about law stuff over the last few years. And, no, she's lived through this, so she knows, too. She's well aware. And just to be clear, my grandfather was a sheriff deputy, retired, and then turned around and went back and became a sheriff's coroner and retired from that. So we're well aware of how they can get away with things because of what we call emoluments violations, using their position of employment as an advantage. But law for thee, not for me, that's their motto. So are they above the law? They're not supposed to be. And how we, the people, retained that power in our own hands was through these suits at common law and a trial by jury, a common law jury. How far such a mode... Oh, yeah, I wanted to reiterate the maxim of law on when we're talking about suits at common law versus equity. The maximum law is that the law of equity may be resorted to where the common law is deficient. So we have to go through the common law first. If the common law is deficient in providing the relief, then we can resort to the law of equity. Let me repeat that. Where the common law is deficient in providing the relief, then we can resort to the law of equity. Let's drill that into to our minds. Common law first. If the common law is deficient, then we go to the law of equity. Okay? How far such, and the reason why I reiterate that, over and over again, because when we go do our general assemblies and it comes times to reinstitute the constitutions, and in certain states like Idaho, we're going to have to create a completely new constitution because the corporate constitution of 1889, supposedly ratified by the people in 1890, is a corporate constitution. We've never had a legitimate constitution in Idaho. Same thing with Washington. So there's no constitution to revert back to prior to where things got subverted with starting essentially in 1861, but I'll go clear back to 1845 in reading in some of these right here, the federal and state constitutions, colonial charters, and other organic laws of the state, territories, and colonies. This one's volume 1. There's 7 volumes. Okay? And this one talks about it. Talks about this trial by jury stuff and how we're supposed to have this General Assembly, which is this one here, the Virginia Constitution, and we'll go back to that Ordinance of Virginia, 1621. What's this? Which council shall be called the General Assembly. 1621, the General Assembly. Okay, back to Blackstone's. So this is the principal defects, right? Therefore, is sometimes had by consent, even in the courts of law. How far such a mode of compulsive examination is agreeable to the rights of mankind and ought to be introduced in any country may be matter of curious discussion, but is foreign to our present inquiries. It has long been introduced and established in our courts of equity, not to mention the civil law courts, that's that Roman civil law. And it seems the height of judicial absurdity that in the same cause, between the same parties, in the examination of the same facts, a discovery by the oath of the parties should be permitted on one side of Westminster Hall and denied on the other. Or that the judges of one and the same court should be bound by law to reject such a species of evidence if attempted on a trial at bar, but when sitting the next day as a court of equity, should be obliged to hear such examination read and to found their decree upon it. So it's like a double standard. Well, it doesn't work over here, but it'll work over there. Okay. I kind of want to move on down because, whoa. What is this? This is mentioned the Common Law Procedure Act of 1854 now, however, enables either party, by leave of the court or a judge, to interrogate his opponent upon any matter as to which discovery may be sought. It's called deposition. And to require such party to answer the questions within 10 days by affidavit sworn and filed in court in the ordinary way. Now, there's another one that I, in my particular case, that I had mentioned at the motion to dismiss debacle there. Said, hey, I haven't received any affidavits under oath. And the stand-in deputy prosecutor, oh yeah, we'll respond with an objection to that motion to dismiss, and he'll have a couple of affidavits under oath. Never received any of that. I already made that in the record. Never received any affidavits under oath. I demanded them. Never got them. It's in the motion to dismiss. They have to respond in writing, proof of jurisdiction, contracts, all that stuff, and it has to be under oath. The record's there. So when it comes time to do the investigation, an inquiry into their conduct to see if they've exceeded their powers, well, some people might be getting arrested and going to Gitmo. Just saying. Let's see if I can find that. I think it was right here. Progress of the Laws of England. Yep. Man, I really want to cover this, but I'm running out of time because this lays out the basically like the different types from the earliest times of the Norman Conquest, from the Norman Conquest to the reign of King Edward I, from thence into the Reformation, from the Reformation to the restoration of King Charles II, from thence to the Revolution of 1688, from the Revolution of the present time. So this is the improvements of the law, of the common law, right? And let me see if I can find where it was saying that. I know. I can look over here because I posted it. A screenshot of it. Yeah, it was 412, right where I'm at right now. Okay, I don't know why. Oh, probably because that was a setting at the time. Right here, the name of the common law. So we're going to go back up here, just right here. From King Edgar, who besides military merit is founder of the English Navy, was also a most excellent civil governor, observing the ill effects of three distinct bodies of law prevailing at once in separate parts of his dominions. Projected and begun that his grandson, when his grandson, King Edward the Confessor, afterwards completed one uniform digest or body of laws to be observed throughout the whole kingdom, being probably no more than a revival of King Alfred's code, which some improvements suggested by necessity and experience, particularly the incorporating some of the British, or rather, what's this? American customs, and also such of the Danish as were reasonable and approved into the West Saxon lay, which was still the groundwork for the whole. And this appears to be the best supported and most plausible conjecture, for certainty it is not to be expected, of the rise and original of that admiral's system of maxims and unwritten customs, which is now known by the name of the common law, as extending its authority universally over all the realm, and which is doubtless of Saxon parentage. So many people talk about the Anglo-Saxon stuff, and then somebody say it's Judeo-Christian. No, right here, it's Saxon common law. The use of maxims of law and our customs, which are religious customs, from the Bible. Like, thou shalt not commit murder, thou shalt not steal, thou shalt not bear false witness, or those without sin may cast the first stone, which we've turned that into the clean hands doctrine. Okay? So, right here, this destroys the argument that the common law is stare decisis case law. Coupled with the Seventh Amendment, suits it common law, would that mean that that's suits it case law, stare decisis? You know how many members of the bar I've shut down with that argument alone? Now I have this proof of the origin of the common law is maxims of law and unwritten customs. Imagine that. So, I'm going to jump to that. Let me cover the Holy See, Vatican. Where in the heck? It's right here somewhere. Something about the Saxons and and they were against that Roman civil law from the Holy See. Materials upon which they were naturally employed in the infancy of raising state, where those of the noblest kind, the establishment of religion and the regulation of civil polity, Roman civil law, yet having only such tools to work with, their execution was trifling and flimsy. Both the divinity and the law of those times were therefore frittered into logical distinctions, and drawn out into metaphysical subtleties, with a skill most amazingly artificial, but which serves no other purpose than to show the vast powers of the human intellect, however vainly or preposterously employed. referring to maxims of law, I'm guessing here. Hence, the law in particular, which being intended for universal reception, ought to be a plain rule of action. Yeah, it's about the maxims of law and those customs. Became a science of the greatest intricacy, especially when blended with the new refinement and grafted upon feudal property, which refinements from time to time gradually introduced by the Norman practitioners with a view to supersede, as they did in great measure, the more homely but the more intelligible maxims of distributive justice among the Saxons. Would that be really the Protestants from the Christian religion? And to say the truth, these scholaristic reformers have transferred their dialect and finesse to posterity, to interwoven into the body of our legal polity, that they cannot now be taken out without a manifest injury to the substance. Statute after statute has in later times been made to pare off these troublesome excrescences and restore the common law to its pristine simplicity and vigor, and the endeavor has greatly succeeded, but still the scars are deep and visible, and the liberality of our modern courts of justice is frequently obliged to have recourse to unaccountable fictions and circuities of order to recover that equitable and substantial justice which for a long time was totally buried under the narrow rules of fanciful niceties, metaphysical, and norm. That this is the Normandy stuff. This gets into the innovation was the introduction of the trial by combat for decision of all civil and criminal questions of fact in the latest resort. Immemorial practice of the northern nations, but first reduced the regular and stated forms among burning. Where in the heck was this about the Holy See? Should have been right there. But the last, the most important alteration both in our civil and military polity was in grafting on the landed estates. Few only accepted the fiction of feudal tenure, which drew after its numerous and oppressive train of servile fruits and appendages, aids, reliefs, primary wardships, marriages, escheats, and fines for alienation. The genuine consequences of the maxim then adopted that in the lands of England were derived from immediately of the crown. I bookmarked this to have to do something to do with the Holy See. Holy See should have been on there. Oh, it's at 419. I'm almost there. It's right here. Right where I just left off. The nation of this period seemed to have groaned under an absolute slavery, as was in the power of a warlike and ambitious and politic prince to create. The consciousness of men were enslaved by sour ecclesiastics devoted to a foreign power and unconnected with the civil state under which they lived, who now imported from Rome for the first time the whole farrago and superstitious novelties which have been engaged in blindness and corruption of the times between the first mission of Augustine the monk and the Norman conquest, such as transubstantiation, purgatory, communion in one kind, and the worship of saints and images, not forgetting the universal supremacy and dogmatical infallibility of the Holy See. Vatican, the Pope, under Catholicism, Roman civil law. The laws, too, as well as the prayers, were administered in an unknown tongue, like code, speaking in tongue code. The ancient trial by jury gave way to the impious decision by battle. The forest laws totally retained all rural pleasures and manly recreations, and in cities and in towns the case was no better, all company being obliged to disperse, and fire and candle to be extinguished by 8 o'clock at night at the sound of the Melacholi, I can't remember how to say that one, curfew. So they used to have a curfew at 8 o'clock at night, which in a way kind of sounds like a good idea in the city parts, right? Lots of crime. You know, nothing good happens after 10 o'clock, as it goes saying here, after the sun goes down. The ultimate property of all lands and considerable share of the present profits were vested in the king, or by him granted out to his Norman favorites, who, by a gradual progression of slavery, were absolute vassals to the crown and an absolute tyrant to the commons. So here it is, being exposed throughout history, the timeline. Okay, now we're going to get into that Roman civil law. Here we go. The usurper Stephen. Remember when I showed you that from the beginning? As the manner of usurpers is, promised much at his secession, especially with regard to redress and grievance of the forest laws, but performed no great matter either in that or in any other point. He's just a frickin' great usurper. It is from his reign, however, that we are to date the introduction of the Roman civil and canon laws into this realm. Okay. That would be this jackwagon. Now remember, I've showed this before. We'll go back over here real quick. Bouvet's Law Dictionary, 1856. Right here. Although successful in the West, these laws were not... I got to go to the beginning because some people may not have seen me turn. Law, civil. The term civil law is generally applied to eminence of the civil or municipal law of the Roman Empire, without distinction as to the time when the principles of such law were established or modified. In another sense, the civil law is a collection of laws comprised of the institutes, the code, and the digest of Emperor Justinian and the novel constitutions of himself and some of his successors. We're going to jump down to number 3 because although successful in the West, these laws were not, even in the lifetime of Emperor, universally received. After the Lombard invasion, they became so totally neglected that both the code, capital C, and Pandects were lost till what? The 12th century, when it is said the Pandects were accidentally discovered at Amalfi, and the Code of Ravenna, but if fortune would make an atonement for her former severity, they have since been the study of the wisest man and revered as law by the politest nations. Really? The Roman civil law, the code, huh? By the term civil law is also understood the particular law of each people opposed to natural law, or the law of nations which are common to all, the common law. So it's opposed to the laws of nature, the law of nations, and the common law. Damn straight it is. And then it's all enforced through bills of pains and penalties. Right? Oh, it's prohibited conduct, productive of the greatest political happiness, and prohibiting actions contrary thereto, and which is enforced by the sanctions of pains and penalties. This is why I'm talking about we're being subjected to this jurisdiction foreign to our Constitution and not acknowledged by our laws. I mean, subjected to these pretended acts of legislation. Now, this goes back to this jackwagon here. That's during his reign, 1135. That's 5 years after they were found. This is the usurper who brought back the Roman civil law. The Code, United States Code, Code of Federal Regulations, Uniform Commercial Code, Idaho Code. Code is Roman civil law. It subverts our common law, our rights. This is why they don't recognize the Constitution. This is why they don't recognize our rights. Because the code is the law. And let me show you where it says that in our Idaho's first legislative, or 11th. Oh, I thought I had that one up. I don't have that one pulled up, but I'm going to dig for that real quick. I already know where it's at. Because I want to show you the proof. And I've already showed this before, but this is the 11th session for the legislative session for the territory of Idaho. Okay, 1881, before we had a constitution here, because Idaho Organic Act for the Territory of Idaho was 1863. So you want to remember this timeline here, that this Code of Civil Procedure. I should have this one bookmarked too, but I'm just learning about the bookmark. Right here, the very beginning, the first thing they did to establish a Code of Civil Procedure for Idaho Territory. The Code of Civil Procedure. An act. This act, no part of Number 3, the rule of the common law that statutes and derogation thereof are to be strictly construed has no application to this capital C code. The code establishes the law of this territory, respecting the subjects to which it relates, and its provisions and all proceedings under it are to be liberally construed with the view to effect its objects and promote justice. The provisions of this code, so far as they are substantially the same as the existing statute, must be construed as continuous thereof and not as new enactments. So this is where they subverted that, right? And I'll show you. Watch this. Y'all think I'm crazy, but here's the proof. Going here to what's supposed to be the Idaho statutes. As soon as you get in here, it's code. Courts enumerated. What are the courts for Idaho? Chapter 1, Section 1, Title 1, Chapter 1, Section 101. Courts enumerated. The following are the courts of justice of this state: the Supreme Court, the Courts of Appeals, the District Courts, the Magistrate Division of the District Courts. CCP 1881, Section 17. That is the Code of Civil Procedure. This is the Roman civil law. Our courts are practicing the Roman civil law. And the code is the law. Anybody have any questions or doubts on this now? Anybody? Public servants out there that may be watching right now or watch this later? How much more proof do you need that we've been turned back into this Roman civil law under the monarchy, which is part of Article 4, Section 4, to guarantee a republican form of government, to keep us from turning us back into a monarchy? Article 4, Section 4, to guarantee a republican form of government, right? What was it about? What's the guarantee clause about? Luther versus Board of the Supreme Court held the question arising of the guarantee are generally political and not judicial. So this isn't really even a judicial question, although we're doing constitutionality challenge. But this is supposed to be up to Congress to determine what's republican in character or conduct, right? It rests with Congress to decide what government is established in a state, as well as its republican character. Subject not subject to judicial review. Article 4, Section 3, it was generally up to Congress to organize and recognize new republican governments in these states. Admission to the, right? Ooh, they do talk about Texas v. White. President's Act is establishing temporary state governments in the defeated Confederate states at the end of the Civil War was justified as an exercise of his power as Commander-in-Chief. So it was there. I just missed it earlier. So there it is right there. Texas v. White. But it's the power of Commander-in-Chief. Now, previously, before they modified this, was it said that the president, only acting as Commander-in-Chief, has the power to set up provisional government pending the outcome of the war. This is why I keep saying, reminding people that we are at war. And we are under this continuity of government. That is the provisional government per the Commander-in-Chief. So some of the things that we're seeing right now, including forcing the DOJ to do this investigation, is trying to find the problem in a public manner so everybody gets to see it. They're going to publish their findings to the general public. So everybody's going to get to learn about this. We all get the opportunity to learn the law. Imagine that, folks. So, now that you know, oh, wait, I got to find that part where it talks about turning us back into a monarchy as one of the right here. Along with concerns about rebellions, delegates expressed fears that a monarchy might arise in a particular state and establish a tyranny over the whole United States. So, this is what that's supposed to be. To secure Republican government, to suppress domestic commotions or internal insurrections. Because that's the first part. To protect against foreign invasion and, upon request by a state, protection against internal insurrection or rebellion, they say. But that's what domestic violence is internal insurrection, an attempt to overthrow the Constitution, and war against the people, the law of its creation. This is why we're at war, folks, and it's time to determine who the affrayers are and who's being afraid. Affrays are acts of violence. So, common law terms. Back to that kind of stuff. That's what's going on with the DOJ right now. They're doing an investigation to see who's in violation of the law. This is what's coming, folks. We're getting back to our republic and our foundation, the law, the common law. James out here on YouTube says 11.3 Law of War Manual. Yeah, well, Article 4, Section 4, Constitution of the United States of America. I mean, that's what it says right here. We're reading it on the screen. This is a duty of the executive branch, as well as Congress, but wherein the Congress cannot be convened against domestic violence, that falls on the executive. And it's not subject to judicial review. This goes back to exactly what Attorney General Barr was saying, that the executive branch was going to start exercising powers that properly belong to the executive branch, and the judicial branch doesn't have a say in it. They can just deal with it. I covered that when it came out. Now, Chris was still alive then, so that's prior to November 15th of 2020 when I put that out. I've been laying this stuff out since 2017. And I came on Facebook, started lives on Facebook in September of 2017. End of September. So, ever since then, oh, look who decided to show up. I know you're busy. Glad to see you here. I'm glad you're able to be here. And you know who I'm talking about. You know who you are. And it's just been affirmed. I'm right on point. Imagine that. I have this beautiful mind that God gave me, and I'm actually using it today. Sometimes. Okay, I'm not perfect, dude. I have lots of my own flaws. I'm plenty ignorant in other things, so don't think I have this big old ego over there, because trust me, I knock myself down with my own, ego stuff. So, but the fact does remain that I do a lot of reading, I do a lot of studying, and I have an extremely high mechanical aptitude, so I get things easily, putting things together and understanding the mechanics of things and how things work just by looking at it sometimes. Many times I've done that throughout my life. So without any formal training or education, I haven't been indoctrinated. I don't have a piece of paper that says, oh, I completed this course. I was indoctrinated by these people. Again, I always go back to maxims of law. Ignorance of the law is no excuse. You cannot claim that you don't know this stuff. But this is one of the things that has helped me through my life here is the frustration and angst that it brings. It literally kind of gets into the crazy realm of things and not understanding, asking the question, well, why people do the things they do. What are you, stupid? Well, yes and no. One, you're ignorant, but the reality is we've all been taught wrong, which is why I endeavored down this road to go here. Sitting in a jail cell in 1995, I made a vow to God that I would start studying the law to essentially, effectively defend myself from the corruption I was experiencing in 1995. Okay? I didn't know that it was going to turn into this. I didn't know that I might end up turning into being one of the new founders because of my studies and research. You know, in some aspects, I keep asking the question: is can I honestly, can I be the only man that knows this stuff? I really don't want to believe that. There's got to be other people out there that have studied this stuff. Where are you? Where are you, folks? Where are the wisest men of the nation? Because that's who's supposed to be working on the assembling our governments, our constitutions, the General Assembly. That's in Blackstone's Commentary on the Law of England there. I actually want to show that just so that people understand what I'm talking about. Come on. Was it? I don't know. This is the one that, yeah, I want to show that right there. Public policy and national concern, right? In matters of public police, no, in matters of public policy and national concern, it enjoined a uniformity of weights and measures, gave new encouragements to commerce by the protection of merchant strangers, and forbade the alienation of lands and mortmain. Oh man, where was this? That part that was talking about. I don't think I bookmarked it. But it was talking about the General Assemblies and stuff and having the wisest of men doing this stuff. And I talked to Destry about this yesterday. Talked to him on the phone. It was after this, I know it was. Well, I'll find it. I'll find it for next time. So, again, if you'd like to help support me, we'll go over here to my website real quick, and then we're going to go to the National Assembly website. So here's the links to my Facebook page, Telegram channel. That's to Patreon. Okay. There's to the YouTube channel, and there's to the Rumble channel. So those are the links to my social media stuff and to Patreon. Right here is also the same link to take you to Patreon. But like I said, I don't want to click on this because it looks totally different because I'm as the owner of it or whatever. It doesn't look anything like what you'll see. It's totally different. So, and if you'd like to send, because they've taken my digital down. They PayPal, Cash App. What's the other one there? The one that Apple uses connected to PayPal. Anyway, all of those, they took that down because supposedly I'm a fraud here, right? But that's what they do. They target patriots. So for those that'd like to send a donation to me at the office, send it to me, Kirk Pendergrass, at 6477 West Fairview Avenue, Suite C, Boise, Idaho 83704. Okay. Whether that's a postal money order, regular money order, cashier's check, cash wrapped in aluminum foil, personal check, whatever, I'll just deposit it in my bank. That's what I do with them. So it helps support me because I've dedicated my life to this, right? I've been now, just over 2 hours tonight dedicating my life to this. And I have for years. This is what I do now. So, yeah, I guess that kind of goes in line with the vow I made to God to start studying law. Like I said, I didn't know it was going to turn into this. Now, furthermore, library tab. Is he going to go? Okay. Reading material. Treatise on arrest and false imprisonment. I put these in order of things to read first. Okay. Then you get down here into the common law stuff, and right here, Lex Parliamentary Americana, elements of the law and practice of the legislative assemblies in the United States of America by Luther Stern Cushion. Okay, Stern's Cushion. This is the book for those out there that want to do the General Assembly stuff and get involved in the Parliament, legislative branch, the General Assembly stuff. You're going to need to learn that book. And I started that Telegram channel stuff, and I asked people to read from this book. Just open it up, pull it up, look at the table of contents, find something that might interest you, read it, and share your knowledge. Make this a group effort to read this and gain this knowledge. If we work together and spread the load out to learn this, it makes it easier for all of us to learn this at the same time. Otherwise, it's just me sitting here reading this stuff, trying to find time to read I don't know what. I've got all sorts of crap I'm trying to read, and I need some help. And you're going to have to learn this stuff anyways, because how in the heck are you going to run the General Assembly if you don't know the law and practice? We'll fall on our face. Okay? And then this is Joseph Story's Commentaries on the Constitution. 3 volumes. You want to listen to his dissertation? There it is. Then I've got Bouvet's Law Dictionary, 1856, right here, the one I was just showing. Black's Law Dictionary, 4th edition. And a collection of what? Maxims of law in law and equity. Why would I have that there? Because that's the common law. Maxims of law. All right. Now let's go over to National Assembly. National-assembly.net. Oh, Destry's working on a new website for National Assembly and other server and occasionally point to this domain to his testing and functionality. If errors are encountered, please have patience. I'm doing some testing. All right. The greatest show on earth. Oh, that's a new one. Change that here. Donald Trump told the American people we'll have a new government controlled by the people. You just found it. Now, I'm going to reiterate this again. This is the only ones that are doing it lawfully, correctly, and have the support of the military. Let me reiterate that again. These guys are the only ones that are doing it lawfully and have the support of the military. There is nobody else doing it lawfully and having the support of the military. Now, Michigan was assembled in 2012. Carl Miller was around then. He was part of that stuff. This is the stuff he was referring to that needed to get done. Being instructed by the military. Okay? But right here, conference call info, the second tab over. Where our weekly call is Thursday nights, 6 p.m. Pacific, 7 p.m. Mountain, 8 p.m. Central, 9 p.m. Eastern. Okay? I guess they brought back doing the assembly business first, because this is about education over here. It's not actually the National Assembly, but it's the education stuff, but it is essentially a business providing education, kind of like Kirk's Law Corner LLC, providing education, news, other services. But they have a business meeting portion. And then the second part is the general discussion, teaching, educational part. And I want to thank those guys out there that have been doing some of these lately. Oscar and Jason and Bill. I wish I could remember Bill's website off the top of my head. He cited it so many times to us. I should know it by now. And I've been there a couple of times and I can't remember it. But this is where we're meeting Thursday nights, folks. And we're trying to get people to come together and reassemble government de jure lawfully with the support of the military. So when the military does come in under Executive Order 13818 to do what they're supposed to do pursuant to Article 4, Section 4, as well as the Law of War Manual, but more specifically, the Law of Nations already dictates this. And for those that don't understand why I keep citing the Law of Nations, why does the Law of Nations have anything to do with this? Well, because one, it's regarded as international law, but number two, to give it further effect, it's in our Constitution. I know a lot of people didn't know that. I had somebody the other day, what do you mean it's in our Constitution? Yeah, it's in our Constitution. It's Article 1, Section 8. Where is it? Right there. To define and punish piracies and felonies committed on the high seas and offenses against the law of nations. That's where it states the law of nations. And the law of nations is regarded as international law. But see, the Roman civil law, the code, is opposed to the law of nations. So this is why we're at war. We have an ideological conflict. And we have subversion of law. We've been invaded. And we have domestic violence going on. Internal insurrection. Which is, again, why the DOJ is being forced to do an open public investigation to see if they're exceeding the law, the Constitution, because Trump forced this back under military control, which he has that power. See Article 4, Section 4, and Texas v. White, and the Law of Nations. Under war and peace. This is the power of the military, which is outside of the Constitution, goes to the Law of the Nations. So, okay, see how this all works together? That's what's going on, folks. And they're going to publish their findings for the general public. Wonder why that is. Why the DOJ? Because they're so freaking corrupt. This is going to force them to expose their corruption of what they're doing that's unlawful. Indirect conflict with our rights and the Constitution. We're back to the rule of law. Law and order. It is coming back. We're getting our republic back. But like Trump said his inauguration speech in beginning of 2017 there, that he was putting the power back into the people's hands. All political power is inherent in the people. We have the right to alter, reform, or abolish anything anytime we deem it necessary. How's that done? We need to reassemble the General Assembly. We need to reassemble government de jure. And until we do that, we're just going to be stuck here under martial law. And that's the word from the military. So when they come in, and we're already under martial law, but when they openly, everybody gets to see it. So you're going to get to see this one way or another, folks. I mean, there's no ifs, ands, or buts about it. It's going to be in your face. When they come in and take down government de facto and declare martial law openly, so we're all aware of it, and we may have a curfew. Might have to be in your houses at 8 o'clock at night because we're under martial law. So they can round up the bad actors, government de facto, those involved in serious human rights abuse and corruption, per the law of nations under war and peace, per Article 4, Section 4, the law of the land or supreme law of the land. This is the power that belongs to the commander-in-chief, the military. And until we reassemble, we'll be stuck under martial law. So you have a choice to make now, folks. And I implore you to come together. Get them 35 people together. Get on the National Assembly weekly call. Get connected. And for those coordinators, moderators, whatever, ComSec, whatever you got going on for your particular country, nation, state, a country, per the law of nations, as it says, the nations or states are, the nation is composed of the body of all of the countries. That's why we have our own governor and we have our own flag, because we're countries. State is a state of being. We're grateful to Almighty God here and under the Christian religion as our ideology. Our theoretical foundation of all government is Christianity as our ideology. So we can either start working on that now and get that done now before, so we're ready to rock and roll once the military does come in and take this down, or we can sit here and suffer under martial law and go, man, somebody ought to do something about this. We're under martial law. Somebody ought to do something about this. To quote Carr Miller again, be a somebody, folks. All political power is inherent in the people, not American state nationals. So if you've done any of that kind of paperwork over there, you're excluded. You're a foreigner. I mean, that's what you declared yourself to be, a foreigner. But you don't understand that a national has to do from the United States Code, the Roman civil law, under the monarchy, that corporation. You just joined the club. You're a member as a national. You're a member of that over there, that bankrupt corporation that's the swamp that's being drained off our land here in America. We're Americans here, not American state nationals. We're people. We're inhabitants, or capital C, citizens. Because again, that definition comes from Book 1, Chapter 19, subsection 212, what a citizen is. That's a member of a civil society who is bound to perform certain duties and is subject to its authority. Imagine that. Our founders wrote those exact words in Article 6, Clause 3. All the aforementioned senators and representatives and members of the legislative, executive, judicial, both state and federal, shall be bound by oath or affirmation to support this Constitution. They're the citizens. Public servants are citizens. Then we have the free inhabitants, to quote Articles of Confederation. Go back to Section 213, which is right after citizen in 212, and there's a different type, a kind of citizen, which will, call that the people. Those are the three statuses we have here in America: inhabitants, people having political power, and citizens. Those are the public servants. And we, the people, have all political power. The inhabitants do not have political rights, while they still have all of their natural God-given rights. And we, the people, ensure that they do have all of those rights, and that they have nothing to do with government. Government has nothing to do with them. And we're supposed to defend the inhabitants. But the inhabitants can also come to our aid in defense, because you do reside here or live here, right? And this is what I've said before. Even in the Law of War Manual, even the Law of Nations, even right down to our code for the manual for sheriffs, is to call upon the inhabitants for what? Domestic violence. I mean, why do they use the word inhabitants? Ugh. I really wish people would get this stuff. But that's my frustration. That's me, right? That's my issues. But I get it. We've all been dumbed down. We've all been lied to, and it's reading means reading. And I keep reiterating this stuff again. People keep saying it. I will do it again. Say it again because we need it, right? I mean, the Telegram channel is created there for all of the individual states on Telegram, and the main one, KLC American Patriots, but can't seem to get anybody to do anything, to learn, to read, to educate themselves. So, I don't know. Right? Fix it fast. Need a bigger reading hammer. Yep. I got lots of reading to do. That's the other one. The formation of the states, whatever. Documents of the formation of the Union American States. Anyways, there's a lot of reading there for me to do. But God bless you all. Have a wonderful night, and thank you all for being here. I do see the numbers growing, and I know that I'm competing with Monday Night Football stuff. So I don't do any sports stuff. I don't hardly watch TV at all. So I've been watching a little bit of that Real America's Voice on our local TV. No. Somebody out on Rumble talking about David Jose. No. Do not check out David Jose. Learn from me and do the stuff through the National Assembly stuff. Okay? Listen to what I'm telling you, folks, and what I'm teaching you. Not these other crackpots who think they know what they're talking about when they don't. They get one little thing and they think they know everything. They don't know jack. And I'll challenge David Jose and any other man who thinks he knows stuff to come here and debate me. Bring your law. But don't get pissed off at me when I bring law that's higher than what you're bringing and expose you for the fraud that you are, or the fraud that you're bringing. Okay? So, yeah, that'll stand. That challenge stands. And I'm going to have a hard time being convinced otherwise when I'm actually looking at foundational documents and history of law like Commentaries of the Law by Blackstone. Okay? And explains a lot of history stuff there. You're going to say you're going to bring something that's contrary to that, and that Blackstone's Commentaries on the Law of England is wrong? Something wrong with your thinker. I bring forth facts of law, real law, and expose the Roman civil law, the code. Now that I know, and now you folks know, everybody who watched this video tonight, you all should know that the code is the Roman civil law. And that's what's happened to our republic. It was hijacked. Might as well go back to 1845 with the Congressional Act extending admiralty jurisdiction on the land, and everybody thinks it's admiralty jurisdiction, when in reality it's Roman civil law. It's a complete different body of law. It's opposed to the laws of nature, the law of nations, and the common law. It's its own code. Now you know. And to know the difference is to say no to the difference. God bless. God bless America. Let's get her done, folks. Let's get our